Hi, my name is George Shaler. I'm the president of the Justice Information Resource Network, and I'm here today with Julia Bergeron-Smith and Tara Wheeler. I'm going to let the two of you introduce yourselves and explain briefly your role and the agency you work for.
Thank you, George. I am Julia Bergeron-Smith. I'm a policy associate and the director of the Maine Statistical Analysis Center.
And I am Tara Wheeler. I am a research associate, and I'm the lead analyst of the Maine Statistical Analysis Center.
I was just going to add that we are a university-based SAC, and so we're located within the Catherine Cutler Institute at the University of Southern Maine.
Thanks, Julia. Thanks, Tara, and welcome. So tell me about the title of your report and how this project came about.
Yeah, absolutely. So today we are discussing our project and a report that was funded by an FY23 Bureau of Justice Statistics SJS award. And the report, it was titled Assessing Protection from Abuse Orders in Maine. It details what turned out to be an 18-month research project for the Maine SAC.
And what was the policy question that you were trying to answer with this report?
Yeah, so back in early 2023, we were, scoping out possible research projects with our partners, and the Maine Coalition to End Domestic Violence told us about how Maine's Protection from Abuse statute offers victims of domestic abuse, various types of relief in their temporary and final PFA orders. However, their advocates and other justice system partners have not really been able to learn about if and how these reliefs are being ordered, because in Maine, PFAs are handwritten. And so therefore, most of that relief information is not available because it's not actually submitted into the court's electronic case management system.
Wow, handwritten. Wow. So can you give me a brief overview of your approach and the data you used in doing this project?
Absolutely. So I'll give you a little bit of it. Tara will give you the rest. But in order to get at that PFA relief data, we realized someone needed to hand review every file in a given year across the state in order to generate a data set. And so that's what we did. Actually, us and then two other staff members traveled over 3,400 miles to 25 different courts to scan all those documents.
Yes, it was quite the adventure. And for the purposes of this study, we focused on 2023 case filings. So that resulted in a final PFA. So it had to have a final PFA to be included in our study. And total, that was 2,079 cases. So a lot of cases that we manually hand reviewed. And so for each of those cases, we collected information from 3 documents. One was the initial complaint, which contained relationship information, so the relationship to the defendant. The second document was the temporary protection order, because we were looking at firearm relinquishments within the temporary protection order. And then finally, we scanned every final protection order. We scanned them and used a software program called Remark to read the scans and generate the data set. So that is how we came up with a data set of 2,079 final protection orders and related information.
Wow, that was quite an undertaking. So what were some of the main outcomes or results from this study?
Good question. So we found that the vast majority of final PFAs were filed against intimate partners, so someone who had a current or former intimate partner relationship, and they were issued for exactly 24 months, which is the standard length of time of a PFA. The statute allows for up to 24 months on an initial PFA. Interestingly, we also found that the proportion of PFAs filed in each region didn't really align with the overall population patterns. For instance, the 2 most populous regions in the state, which are Cumberland County and York County, they make up 38% of the state's population, but only made up 24% of protection orders filed within the state. So that was kind of an interesting finding. We also found that while the majority of temporary and final PFAs included firearm relinquishment provisions, these rates varied by court region, with the most rural regions having lower rates of relinquishments in both temporary and final PFAs. So at both points that one can relinquish a firearm order relinquishment. Then another interesting finding was that there's two narrative fields on the form, and they're being used as a catch-all. As Julia did a great analysis of these narrative fields, and a lot of times they actually contained information that was available elsewhere on the form, but for some reason it wasn't checked elsewhere. It was just used in these narrative fields. And our partners found this very insightful, because when they use these two narrative fields, there's not criminally enforceable, where if they had checked the appropriate fields before, it would have been criminally enforceable. So that was a helpful insight to for our partners. And then finally, our final big finding was that final PFAs and the types of relief granted in them varied significantly by PFA determination type. So in Maine, a PFA can be determined one of two ways. So by both parties coming to an agreement prior to a hearing. These agreements are often facilitated by an attorney and or a advocate. And the other way is that there's a full hearing, and then the judge makes a decision on what types of relief are granted within the PFA. So we found that this determination type really did impact almost all other data points looked at. So for instance, final orders determined by agreement of both parties were less likely to require the defendant to relinquish firearms. So for those PFAs with determined by both parties, only 39% of them relinquished firearms, compared to 67% when it was a judge who determined the types of relief. And also it influenced custody provisions with the PFAs being determined by a judge being more likely to grant sole custody than if the determination type was by both parties. So that was just very interesting about how that determination type impacted other variables. And our partners also found that interesting because they worked directly with victim advocates who are helping make those, those agreements.
Thanks, Tara. So what does this all mean? And what are the policy implications for going forward for this study and for the people who asked for this report?
Yeah, so I can take that. So we heard from our partners at MCEDV that this data will help them know where to concentrate their resources, so their court advocates, and then also which district courts they would like to engage in additional training or additional technical assistance. Additionally, too, they said that overall these findings provide useful information about the types of relief being granted in final PFAs, which just really hasn't ever been done before. So it is really a first of its kind study for Maine. Yeah, and I'll also add too that it's really going to help MCEDV determine what their trainings look like for court advocates as well, because being able to see what their engagement in the process really does and how it impacts the process, it just gives them the information that wasn't there before, that maybe they knew about, maybe they kind of saw the writing on the wall, but now we have some real numbers they can work with.
I'll also add that this really just, this study also helped improve our internal capacity to understand what we can research. At first it was daunting thinking that, oh, these are all scanned files, we can't do it, but then realizing there was software that could help accommodate us, and that this could be beneficial to many SACs, rural SACs, where they also might have the same types of, court systems and paper filings.
Well, that's great. Thank you, Tara. And thank you, Julia. And once again, congratulations on this great study. And I think it'll be very